Hello, this is Suzanne Bechtel for your Chapter 3. I have 5 total recorded lectures from the Practical Law Office Management text by Cynthia Train Adonis. We begin with an introduction to ethics and malpractice, covering Chapter 3. These are the objectives that we intend to meet after you finish listening to everything and reading the text. Basically define the unauthorized practice of law and how to avoid it. Discuss voluntary ethical codes of paralegals and legal assistants. Explain the attorney-client privilege and to whom it applies. List guidelines that will prevent paralegals from accidentally revealing confidential client information. And explain what a conflict of interest is and what a law office can do to limit conflict of interest problems and what an ethical wall is. The one thing I disagree with on this list of objectives is the third one where it says privilege. We're really talking about client confidentiality, which are two similar feeling things, but they're really different. So I'll change that in the future. Chapter 3 introduces you, the student, to important topics of ethics and malpractice. Having a high ethical standard is critical to providing quality legal services to clients. In addition, you need to avoid malpractice by having a high degree of competence. So it's likewise going to provide quality services to the client. The chapter introduces you to common ethical problems for paralegals and prepares you for how to handle the problems. Practical tips on avoiding malpractice problems are also provided. And even if you've taken a separate ethics class, this chapter will give you more information that you can understand the topic a little more clearly. Clients and attorneys must have total confidence that a paralegal understands ethical problems and that a paralegal's ethical judgment is clear. A paralegal must perform careful, high-quality work in everything he or she does. An error by a paralegal can be very costly and can subject the attorney to, or the law office itself, to a malpractice claim. A paralegal must also, as I've already noted, a paralegal must perform careful, high-quality work in everything he or she does. An error by a paralegal can be very costly and subject the firm or the attorney to a malpractice claim. What it boils down to is that malpractice harms the client and subjects the attorney to a malpractice claim. It subjects the attorney to potential disciplinary complaint, and the paralegal could be terminated from his or her job. So what are ethics? An ethical rule is a minimal standard of conduct. An attorney's conduct cannot fall below the standard without losing his or her good standing with the state bar. Attorneys who violate the ethical standards may be subject to discipline, including permanent disbarment, temporary suspension, public censure, private censure, or an informal reprimand. The ABA, Model Rules of Professional Conduct, come from the American Bar Association, and the ABA Model Rules, or a form of it, is used in nearly all states. Some states also use the older ABA Model Code of Professional Responsibility from 1969. The ABA convened the Ethics 2000 Commission on the evaluation of the rules of professional conduct to review the model rules and recommend changes to them. They completed this review in 2002. The last revision was done in 2008. And states are free to create their own rules of conduct for attorneys, but most simply modify one of the ABA's ethical models. You're realizing that the American Bar Association is a voluntary organization for attorneys. So, the attorney's ethical rules do not apply directly to paralegals. Neither a state's canons of ethics nor the ABA's ethical rules apply directly to the paralegal. Attorneys can be disciplined for the acts of their staff members, including paralegals, because attorneys have the duty to adequately supervise their staff. if you look at the Model Rule 5.3b of the American Bar Association, the rules of professional conduct, both ABA and state-specific rules, will give you some insight here. For the reasons noted in this slide, though, paralegals are indirectly held to the same standards as attorneys. Also, attorneys can't avoid ethical rules and accomplish an unethical act by delegating or allowing a staff member to do the act. So it applies to attorneys, they're lawyer rules, but they apply to the paralegal and the other staff by virtue of the requirement that the attorney supervise and that he or she hold the same standards to the staff. In addition, although a paralegal can't be disciplined by state regulatory bodies, such as the bar, for violating state ethical rules, the paralegal would be held accountable by the attorney who hired or supervised him or her up to and including termination. In addition, a paralegal can be criminally charged with the unauthorized practice of law. We also call this UPL. And some courts have even upheld civil damages for negligence against paralegals. So, it is in the best interest of the paralegal to understand and abide by any ethical rules governing the conduct of attorneys. Paralegals, on the other hand, have self-imposed voluntary ethical standards that are set out by national or local paralegal associations. For example, the National Association of Legal Assistants, also known as NALA, and the National Federation of Paralegal Associations, also known as NIFPA, they have their own set of ethical standards that their membership are supposed to abide by. Here's an example of the NALA Code of Ethics. As you can see, there's a preface. The paralegal must adhere strictly to the accepted standards of legal ethics, etc. The next paragraph, the canons of ethics set forth hereafter are adopted by NALA, and they're a general rule to guide and aid paralegals and attorneys. Then it goes on to the definition of what a paralegal is, according to NALA's definition. And they've also adopted the ABA definition of legal assistant or paralegal, which is also listed here. And you can see Canon 1, 2, and 3 on this slide. A paralegal must not perform any of the duties an attorney only can perform. Canon 2, a paralegal may perform any task properly delegated and supervised by an attorney. And 3, a paralegal must not A, engage in, encourage, or contribute to any act which would constitute UPL, unauthorized practice of law. And B, establish relationships, set fees, give legal opinions or advice, or represent a client before a court or agency, unless so authorized by that court or agency. And C, engage in conduct or take any action which would assist or involve the attorney in the violation of a professional ethics or give the appearance of professional impropriety. So that's the first 3 canons. And then it goes on. The paralegal, Canon 4, must use discretion and professional judgment. Canon 5, and I'm just briefly reading these, the main idea here, a paralegal must disclose his or her status as a paralegal at the outset of any professional relationship. This would avoid both the impression that you might be an attorney when you're not, so disclosing your status and prudently and repeatedly is what I would say. Canon 6, paralegal must strive to maintain integrity and a high degree of competency. Canon 7, a paralegal must protect the confidence of a client and not violate any rule or statute in effect. And Canon 8, a paralegal must disclose to his or her employer any pre-existing client or personal relationship that may conflict with the interests of the employer. Canon 9, a paralegal must do all other things incidental, necessary, expedient for the attainment of the ethics and responsibilities defined by state law or rule of court. And Canon 10, a paralegal's conduct is guided by Bar Association's codes of professional responsibility and rules of professional conduct. So again, while these aren't lawyer rules here, the lawyer rules do apply, basically because all of those have some similarity to the lawyer rules in the ABA model rules, or if you look to the Florida Bar rules, you're going to see some resemblances. And That's the main idea here. The NIFPA model disciplinary rules, as noted in an earlier slide, the National Federation of Paralegal Associations, or otherwise known as NIFPA, they have voluntary ethical standards for paralegals. You'll see some similarities. Achieve and maintain a high level of confidence, maintain a high level of personal and professional integrity, maintain a high standard of professional conduct. 1.4, serve the public interest by contributing to the improvement of the legal system and including pro bono services and community service, and preserve all confidential information provided by the client or acquired from another source before, during, and after the relationship exists. And finally, a paralegal shall avoid conflicts of interest, a paralegal's title shall be fully disclosed, and a paralegal shall not engage in the unauthorized practice of law. So there are 8 canons with NIFPA, 10 canons with NALA. On the face of things, you can see that they don't have in NIFPA the requirement to follow the rules that the lawyers follow, but for the most part, there are a lot of similarities. So what you've learned from this lecture is a little bit about ethics themselves and voluntary ethical codes established by national associations for legal assistance. That's the primary one from this lecture, and this is the first of 5 lectures, so please go on to the next one, and it's titled Unauthorized Practice of Law.